It is February the 27th, 2026, and this is the Court Gallery. Good evening, ladies and gentlemen. We are in Wisconsin and Michigan tonight in the Court Gallery. We're starting off with Judge Mogan, who's got three individuals who have serious talking tos coming to, and then we're going to Judge Simpson's room in Lansing, Michigan, where she's got another one of these landlord-tenant situations that's just, oh my gosh, untenable. It's an interesting set of cases we have tonight, ladies and gentlemen. I hope you find them as interesting as I did when I was putting them together for you today. It all starts right now.
In the matter 25 CF 54, State of Wisconsin versus Zachary Chafee. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Chafee in person in custody with counsel Charlene Perrin. We're set here today in this matter for a plea hearing. The parties have reached an agreement. Ms. Perrin, can you please recite the agreement for the record?
Yes, the defendant will plead guilty to count one as amended to a Class F felony.
I'm stopping right now because this came in while I was doing the intro, and I saw it, and like an idiot, I didn't even respond to it. Thank you so much, Hannah. That's amazing. I really appreciate you. Now, back to our program, already in progress. I think.
He will also plead guilty to count 4, maintaining a drug trafficking place. There will be a joint recommendation of 2 years, 6 months of initial incarceration. I'm sorry. There will be a joint recommendation of 2 years incarceration for count 1, 6 years extended supervision. On the second charge, there would be a joint recommendation of 1.5 years initial incarceration, 2 years extended supervision, concurrent to each other, eligible for ERP. We would be asking for no PSI for the court to go along with that joint recommendation. That is the agreement.
Thank you. Mr. Chafee, is that the agreement as you understand it?
Yes, ma'am.
Okay. And the basis for that agreement and how it was reached and in the public interest was stated on the record at the last hearing, I believe, due to the fact that I think it was only 15 grams after the lab, something around that nature. All right, so Mr. Chafee, I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document?
Yes, ma'am.
Did your attorney go over this document with you thoroughly?
Yes, ma'am.
Can I have you please pull the microphone closer to him? Thank you. Did she essentially go over it with you word for word?
Yes, ma'am.
And you understand everything completely?
Yes, ma'am.
If you didn't understand something, did you ask her to explain it until you did?
I understood it all.
Excellent. Is that your signature on the second page?
Yes, ma'am.
You are pleading guilty to count 1, an amended count of manufacturing, delivering a designer drug, and you are pleading guilty to 1 count of maintaining a drug trafficking house. Is that correct?
Yes, ma'am.
Formal motion to amend count 1 from a Class C felony down to a Class F felony.
So made.
All right, thank you. You're 37 years old. You have 12 plus years of schooling. You can read, write, you understand the English language. Is that all correct?
Yes, ma'am.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt as to both of these charges?
Yes, ma'am.
Did your attorney thoroughly go over with you the maximum possible penalties you face for both of these charges?
Yes, ma'am.
You are not receiving treatment for mental illness or disorder, and you have not had any drugs, alcohol, or other medications in the last 24 hours, correct?
That is correct.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the first page of that plea questionnaire. Did your attorney thoroughly go over those rights with you?
Yes, ma'am.
And do you understand them completely?
Yes, ma'am.
Now, do you understand that you will no longer have the right to a jury trial? You will no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to have to testify on your own behalf or remain silent and not have your silence used against you. You will no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes, ma'am.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, ma'am.
You understand that you're pleading guilty to a felony. As such, you will no longer be able to use or possess a firearm for life.
Yes, ma'am.
You will no longer be able to vote in any election until your civil rights are restored.
Yes, ma'am.
Now, with regards to this matter, your attorney did attach jury instructions for manufacturing of a controlled substance, as well as keeping or maintaining a place used for manufacturing, keeping, or delivering a controlled substance, i.e. maintaining a drug trafficking place. Did she thoroughly go over those with you as well?
Yes, ma'am.
With regards to yours would be count 2, manufacturing, delivering designer drug. Do you understand that the state would have to prove on or around March 20th, 2025 in Burnett County, Wisconsin, as a party to a crime, you did unlawfully and feloniously manufactured dimethyltryptamine in an amount greater than, or it's in an amount, is it less than 15 grams?
It's 3 grams or less.
3 grams or less. All right, so significant resolution. All right, so I'll go back over that right now. So with regards to this matter, the state would have to prove on or around March 20th, 2025 in Burnett County, Wisconsin, as a party to a crime, you unlawfully and feloniously manufactured dimethyltryptamine, DMT, in an amount less than 3 grams. And that would go from a Class C felony, which you were charged, down to a Class F felony. Do you understand what the state would have to prove?
Yes, ma'am.
And do you understand what it means to be a party to a crime? That means either you directly committed the crime yourself, you aided and abetted someone who was in the commission of the crime, or you conspired with one or more people to commit the crime, and affirmative steps were taken towards that commission of the crime. Do you understand what it means to be a party to a crime?
Yes, ma'am.
Do you understand the maximum possible penalty for this crime could be a fine of up to $25,000 or 12 and a half years of incarceration, or both? Do you understand that?
Yes, ma'am.
Do you also understand then with count 4, maintaining a drug trafficking place as a party to a crime, the state would have to prove on or around March 20th, 2025 in Burnett County, Wisconsin, as a party to a crime, you knowingly maintained a building which is used for manufacturing controlled substances in violation of Wisconsin law. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or 3.5 years of incarceration, or both? Do you understand that?
Yes, ma'am.
Do you also understand that there is an agreement between the parties, and it has been recited on the record and that both sides are requesting not to order a pre-sentence investigation report. Do you understand that?
Yes, ma'am.
Do you understand that I'm not bound to follow any agreement or any request not to order a PSI? Do you understand that?
Yes, ma'am.
I am free in my own discretion to sentence you to what could even be the maximum possible penalty if I thought it was warranted, and I have the authority and the right to order a pre-sentence investigation report. Do you understand that?
Yes, ma'am.
Now, with regards to this pre-sentence investigation report, do you understand what that is?
Yes, ma'am.
And it's going to have it's a document that's going to have a whole lot of information about you, about your history, both your personal, your family, your work, your school, your criminal history. It'll have a bunch of information, and it will also have a recommendation of sentencing from the Department of Corrections standpoint. Do you understand? I'm not bound to follow that recommendation.
Yes, ma'am.
Just like I'm not bound to follow any joint recommendation from both the state and the defense. Do you understand that?
Yes, ma'am.
Do you have any questions before I continue?
No, ma'am.
Now, did you go over that criminal complaint with your attorney?
Yes.
In particular, there is a section, it's called the probable cause section, where it basically says what happened and why you were charged with the crimes. Do you remember that?
Yes.
As it relates to both of the counts you're pleading guilty to, are those facts, for the most part, accurate?
Yes, ma'am.
Are you admitting here today that you in fact did manufacture a designer drug, which would be a dimethyltryptamine, DMT, as a party to a crime?
Yes, ma'am.
Are you admitting here today that you in fact did maintain a drug trafficking place as a party to a crime?
Yes, ma'am.
Are you pleading guilty to these two counts because you are guilty of these offenses?
Yes, ma'am.
Ms. Perrin, did you go over the facts alleged in the probable cause section of the criminal complaint with your client?
Yes.
Did you go over what the state would have to prove based upon those facts, as well as the maximum penalties that he may face?
Yes.
Did you go over with him any potential defenses or a lack of defenses that you could see in this case?
Yes.
May the court use the probable cause section of the criminal complaint to find a factual basis?
Yes.
Has anyone made any threats or any promises to you for you to plead guilty to both of these charges? Other than a plea agreement?
Just a plea agreement, ma'am.
Okay, but no threats, no other promises?
No.
Now, so you're entering your pleas freely and voluntarily. That means you are telling me you fully understand what you're doing here today.
Yes, ma'am.
And you're doing so, again, voluntarily with full knowledge of what you're doing.
Yep.
All right. Has your attorney represented you competently?
Yes, ma'am.
Has she answered all of your questions?
Yes, ma'am.
Has she looked at this matter thoroughly?
Yes.
Has she discussed with you any potential defenses or a lack of defenses she sees in this case?
Yes, ma'am.
Has she discussed with you the discovery and the evidence that does exist in this case?
Yes, ma'am.
Did you discuss with her all of the facts that you know to exist about this case,
Yes, ma'am.
including any defenses you may believe you have?
Yes, ma'am.
Did she thoroughly discuss with you that it's your choice to go to a jury trial?
Yes, ma'am.
And so was this your choice to enter pleas here today?
Yes.
All right. So are you satisfied with her services?
Yes, ma'am.
Do you have any questions for the court or for your attorney before I proceed?
No, ma'am.
Ms. Perrin, do you believe that your client fully understands what he's doing here today by entering guilty pleas?
I do.
Do you believe his pleas are done freely, voluntarily, and knowingly and intelligently?
Yes.
Do you believe he fully understands the elements that the state would have to prove, along with the facts that would support each of the elements?
Yes.
Do you believe he understands the maximum possible penalties that he faces,
Yes.
and that it is the court's discretion in what it sentences?
Yes.
Do you believe he's fully competent to enter his plea here today?
Yes.
And you went over the strengths and the weaknesses of the case with your client?
I did.
Okay. Now, any questions, Mr. Chafee, before I take your plea?
No, ma'am.
Then as to count 2, manufacturing, delivering designer drugs less than 3 grams as a party to a crime, a class F felony, how do you wish to plead?
Guilty.
As to count 4, maintaining a drug trafficking place as a party to a crime, an I felony. How do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of count 2 and count 4. The remaining counts and charges will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. The court is going to order a pre-sentence investigation report. Long form. Agent does not need to appear, but should be readily available by telephone in case any questions arise. The court is hereby revoking bond. We need to set the matter for sentencing. I am ordering the pre-sentence investigation report. As I went over previously with you, I know nothing about you, Mr. Chafee. I don't know if you are a resident of Burnett County. I don't know your criminal history. I don't know your childhood. I don't know if there are things that you truly want me to know about you. That's why I'm ordering the PSI, and it is actually in your benefit for the court to do so. Let's schedule a sentencing.
I can't do the morning on the 8th.
Okay. Do you know how long your arguments will be?
Mine will be short.
Okay. So you want to do 1 o'clock? Can you do 1 o'clock, Ms. Perrin?
I believe that I can. I just want to double check my CCAP calendar. Just to make sure that it is up to date, but I believe that will work.
Okay. Just set it for an hour just in case.
Yes,
So-
that'll work.
May 8th at 1 o'clock, we will have the sentencing. We are adjourned. We will go on the record in the matter 25 CF 53, State of Wisconsin versus Laura Chamberlain. This state appears through District Attorney Kevin Schmidt in person. We have Ms. Chamberlain appearing in person in custody with counsel Renee Landgraf. We're set here today in this matter for a plea and sentencing hearing. The parties have reached an agreement. Ms. Landgraf, can you please recite it on the record?
Yes, my client will plead guilty to counts 1 and 3 by way of a deferred judgment of conviction. Amended count 1 to a class F felony, manufacture designer drugs less than 3 grams as party to a crime. And count 3, class I felony, maintaining a drug trafficking place party to a crime. Again, those are both subject to the deferred. And then she will be pleading to count 5, class I felony, possession of methamphetamine. And for that charge, we have a joint recommendation for judgment entered, sentence withheld 3 years probation.
All righty.
Anything else will be dismissed and read in.
Sounds good. And I believe the basis for reaching this agreement was stated on the record at the last hearing. Lab actually determined that it was under 15 grams, so that went into the negotiations. Therefore, the end of the line agreement was less than 3 grams. Formal motion to amend.
So made.
Granted. Okay, plea questionnaire waiver of rights, I believe, was filed.
It's document 74.
Thank you. And I have the proposed deferred judgment of conviction. Do I have a signed one?
I think that is the signed one. It is. It's signed by all 3 of us.
Excellent. Okay. So, Ms. Chamberlain, you heard the agreement that's been stated on the record, correct?
Yes, ma'am.
And that is the agreement that you've reached with the state.
Yes, ma'am.
Did I ask you formal motion to amend count 1?
If not, I'll do it again.
Granted. Good. Okay. So I have the plea questionnaire waiver of rights form, and I have the proposed deferred judgment of conviction document in the electronic file. Ms. Chamberlain, did your attorney go over both of those documents with you thoroughly?
Yes, ma'am.
Did she essentially read them to you word for word?
Yes, ma'am.
And do you understand them completely?
Yes, ma'am.
If by chance there was something you didn't understand, did you ask her to explain it until you did?
Yes, ma'am.
Did you sign both of those documents?
Yes, ma'am.
So you were pleading guilty to 1 count of manufacturing delivering a designer drug less than 3 grams as a party to a crime, a class F felony, and 1 count of manufacturing or maintaining a drug trafficking place as a party to a crime, a class I felony, and 1 count of possession of methamphetamine, an I felony, as a party to a crime. It says as a party to a crime. I don't know if that's what it's pleading to.
You should probably amend that to no party to a crime because that was.
That was not his.
It was in her wallet.
From
That's
a motion
correct.
to remove party to a crime on possession of methamphetamine.
So made.
Granted. So you're pleading solely accepting that responsibility.
Yes, ma'am.
Now, you are 52 years old. You have a high school diploma and college. You can read, write, you understand the English language. Is that all correct?
Yes, ma'am.
And for the record, you are looking at an electronic version of your plea questionnaire, and you will have the deferred judgment of conviction to look at as well, correct?
Yes, ma'am.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt as it relates to all 3 of these?
Yes, ma'am.
Did your attorney go over with you the maximum possible penalties you face?
Yes, ma'am.
You are not receiving treatment for a mental illness or disorder. You've not had any drugs, alcohol of that nature, but you've had prescription medications. Is that correct?
Yes, ma'am.
Do your prescription medications interfere with your ability to comprehend or understand what's happening?
No, ma'am.
Because you're being charged with crimes, you are entitled to constitutional rights. Each of these rights is listed on the first page of both of those documents. You can see them right now. Now, did your attorney thoroughly go over those rights with you?
Yes, ma'am.
Did she explain them again to you very thoroughly so that you fully understand them?
Yes, ma'am.
And do you understand them?
Yes, ma'am.
Do you need me to go over those rights with you in any more detail?
No, ma'am.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, ma'am.
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes, ma'am.
Do you understand you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes, ma'am.
You will no longer be able to vote in any election until your civil rights are restored.
Yes, ma'am.
Now, do you understand here, with regards to this case, the state would have to prove for count 1, manufacturing a designer drug less than 3 grams as a party to a crime on or around March 20th, 2025 in Burnett County, Wisconsin. As a party to a crime, you did unlawfully and feloniously manufacture dimethyltryptamine, DMT, an amount less than 3 grams. Do you understand what the state would have to prove?
Yes.
Do you understand what it means to be a party to a crime?
Yes.
That means, though, that either you directly committed the crime yourself, you aided and abetted someone who is committing the crime, you conspired with someone who is one or more people who were looking at committing a crime, and 1 or more steps were taken towards that commission of the crime. Do you understand what it means to be a party to a crime?
Yes, ma'am.
Do you understand that with regards to this matter and the amended count from a class C to a class F felony, that the maximum possible penalty could be a fine of up to $25,000 or 12.5 years of incarceration, or both?
Yes, ma'am.
Do you also understand that with regards to count 3, maintaining a drug trafficking place as a party to a crime, the state would have to prove on or around March 20th, 2025 in Burnett County, Wisconsin, as a party to a crime, you knowingly maintained a building which is used for manufacturing controlled substances in violation of Wisconsin law? Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 3.5 years, or both?
Yes, ma'am.
Do I need to go over what it means to be a party to a crime again?
No, ma'am.
As to count 5, possession of methamphetamine, the state would have to prove on or around March 20th, 2025 in Burnett County, Wisconsin, you possessed a substance. The substance was a controlled substance, methamphetamine, and you knew or believed that substance was a controlled substance, methamphetamine. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or 3.5 years of incarceration, or both?
Yes, ma'am.
You also understand that there is an agreement that's been recited on the record, and that would include a deferred judgment of conviction document. Do you understand that I'm not bound to follow either the deferred judgment of conviction or any recommendation for sentencing.
Yes, ma'am.
I can sentence you all the way up to the maximum penalties if I thought it was warranted. Do you understand that?
Yes, ma'am.
Do you still wish to proceed and enter guilty pleas?
Yes, ma'am.
Now, did your attorney thoroughly go over the terms of a deferred judgment of conviction
Yes, ma'am.
and the requirements that you would need to make in order to have this deferred judgment of conviction be successfully completed?
Yes, ma'am.
Now, did your attorney also go over with you the facts alleged in this case, which would be in the probable cause section of the criminal complaint?
Yes, ma'am.
Now, I'm not going to have you say that every fact is accurate, but for the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did manufacture a designer drug here known as DMT?
Yes.
Are you admitting here today you in fact did maintain a drug trafficking place,
Yes.
both as parties to a crime? Are you admitting here today that you in fact did possess methamphetamine?
Yes.
Are you pleading guilty to each of these counts because you are guilty of these offenses?
Yes.
Ms. Landgraf, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No, Your Honor.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has she answered all of your questions?
Yes.
Has she looked at this matter thoroughly?
Yes.
Has she looked at the discovery and the evidence and discussed it with you?
Yes.
Has she discussed and talked to you about any potential legal defenses you could have or a lack of defenses?
Yes.
Did she discuss with you that it is your right and yours alone to decide whether or not you go to trial?
Yes.
Is it your decision to enter guilty pleas here today?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
No, Your Honor.
Are you satisfied with her services?
Yes.
Ms. Landgraf, do you believe that your client is freely, voluntarily, knowingly, and intelligently entering pleas today?
Yes, Your Honor.
Do you believe she fully understands the elements of the crimes as well as the facts that would support each of those elements?
Yes, Your Honor.
Do you believe she understands the maximum possible penalties that she faces and that it's the court's discretion as to sentencing?
Yes, Your Honor.
Do you believe she understands the rights she is giving up here today?
Yes, Your Honor.
Do you believe she is fully competent to enter her pleas?
Yes, Your Honor.
As to count one, manufacturing and delivering designer drugs less than 3 grams, a class F felony as a party to a crime, how do you wish to plead?
Guilty.
As to count 3, maintaining a drug trafficking place, an I felony as a party to a crime, how do you wish to plead?
Guilty.
As to count 5, possession of methamphetamine, an I felony, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of all 3 offenses. A judgment of conviction will be entered as to possession of methamphetamine. I will hear arguments as to all right now. The remaining counts are dismissed and read in for purposes of sentencing. Mr. Schmidt.
I'd ask the court to follow the plea agreement today. The basis for the agreement is 1, Ms. Chamberlain has no criminal history. She got to middle age when this all happened. There were a number of drugs found in the building and she had methamphetamine on her. But the main concern we had when doing this case was the dimethyltryptamine in the dimethyltryptamine lab. The reason why the charges are much lower than what we originally charged is because, as the court recalls at the prelim, we don't really have a good way of saying how much dimethyltryptamine was actually produced, given the state it was in at that time. When I was preparing witnesses, talking to our expert from DCI, as well as the lab people, they could not give me a number or extrapolate based on those mason jars they found how much was actually made. Those mason jars are what are the end result of creating dimethyltryptamine, where basically you keep taking layers off the top and freezing and it becomes dimethyltryptamine. The other reason why the agreement became what it was is through talking with my experts and learning dimethyltryptamine is significantly less dangerous than I thought at the beginning of this. And so was the lab. So dimethyltryptamine, despite the name, is actually a naturally occurring chemical in nature. It is from plants from South America. It's actually legal in quite a few countries in South America. It's not addictive. It causes sort of like LSD-like trips that last about 15 minutes. You can't really overdose on it very easily. You'd have to combine it with something else to actually overdose. It doesn't cause addiction. It's not habit forming. And in fact, there's actually a Supreme Court of the United States case about dimethyltryptamine in Gonzalez v. O Centro Espiriete Beneficiente União do Vegetal.
We're going to need that.
I can give the spelling to the clerk at the end, or the reporter at the end. That's 546 US 418 2006. The Supreme Court of the United States actually held that dimethyltryptamine, the dangerousness of it is not enough that the government can have a compelling interest to bar the use of it religiously. It is used by certain churches from South America in taking sacrament, as well as many traditional tribal uses in South America. Discovering all that about dimethyltryptamine, I had thought it was maybe more of it's in the designer drug statute for Wisconsin, so I thought it was closer to methamphetamine. It's less dangerous than methamphetamine. And the lab itself was also not super dangerous. The reason why the clear team, the clandestine team, went in with so much gear is there were some chemicals there that could have been used to create a substance called ricin, which is a Cold War era like poison. When they got in there and looked more closely, they determined this is not a ricin lab. They took off the PPE, and dimethyltryptamine labs, especially this one with how they created it, didn't have a danger of like explosions or contamination or something like that. The most dangerous thing about this lab would be the basic substance in the mason jars that is used to purify the dimethyltryptamine. So taking those things together, this shouldn't have a sentence like, say, somebody who had a methamphetamine producing lab. That is very dangerous to do. Those labs can explode. They do lots of contamination that can last for a very long time. And this is different than that. So that's why in this case, we did this much lower amount, because I don't know how the jury would find a specific amount in this. We did give a weight for one, I think 2 pulls off of 2 of the jars, but does that really tell you how much was manufactured, or does it tell you how much was in the jar with the basic substance that purifies the dimethyltryptamine? Can't really say. We didn't find any of the actual completed dimethyltryptamine. When it's produced this process, you'd find it would look like some sort of crystal is how it would kind of look, and we didn't find that. We didn't find the sheets that you would probably put it on and put it in a freezer to do that last step. So taking all those things together, all this information, as well as her lack of criminal history, I think she's already sat a very long period of time in custody. She has no criminal history, so that's going to be a pretty significant deterrent to her. She's not going to have access to the building where this happened again, because ownership of this already changed through function of the Polk County Court. And I do think the probation on the methamphetamine is important, because, like I said, if somebody is the age Laura Chamberlain is when they suddenly break bad, then we still have a chance to bring them back to where they were before that. And I think that probation is the best way to do that. Thank you.
Thank you. All right, Ms. Landgraf. First, you have jail credit.
I do. Just had it pulled up here. 344 days, including today. So that's 11 months and 7 days.
All right, so 343. Okay. Ms. Landgraf.
I just want to make sure that the court received my sentencing memorandum. It's document 77.
I read it. It's all good.
Okay, perfect. So not to rehash all of that, I agree with everything that the district attorney said. In fact, I learned some stuff just now. But I think we do have a weight. I mean, there was 3 different weights given in the crime lab report. So I think the jury could find that there was 14.618 grams altogether. I don't know what was all sent there, but that's what was sent. All of the ingredients to DMT can easily be found online. Ms. Chamberlain admits that she and Mr. Chafee were experimenting with that. Despite the law enforcement seizing all of these cell phones and other evidence that was testified to at the preliminary hearing, there's absolutely zero evidence that there was any indication that they were going to sell this or deliver it to anybody. My client states that they were solely just experimenting with it for their own personal use, although I don't think she actually knew that they got to the end point where the DMT was actually manufactured, because they didn't actually consume any of it. But again, she has no criminal history. And I believe her mom is her biggest support system, and is going to help get through this process after she's released today, because she has been incarcerated for a very long time and she's never been arrested or in jail before. So this is an extremely life-changing event for her. And unfortunately, she's a convicted felon after today. I did discuss with her the pardon process, and hopefully she will be able to do that someday.
Okay, thank you. Ms. Chamberlain, anything you want me to know about you, about your past, about where you got to where you are here today, and anything you think about your future?
Thank you, Your Honor, for allowing me a moment to speak.
If you are going to read something,
Yeah.
please read it slowly and enunciate your words. My court reporter needs to take everything down, and I just need to make sure that I can understand it.
Mhm. I'd like to let you know that I have used my time in here to reflect on my situation. I'm grateful. Oh,
Judge, I want to make sure that you got the 2 character letters that were submitted as well.
I did. I read those too.
Okay, thank you. Sorry.
I am grateful that through the support provided to us here, church, Bible study, women's support group, AA, NA, and parenting class, of which I've attended every time that they're here, I have learned many things about myself that I had lost or forgotten. I'm a strong, forgiving, loving woman. I have peace in my heart that I haven't in a long time. I found myself again. I plan on getting a job, a place to live, and to contribute in a positive way to my community. I believe I'll be able to do this through the support of my family, friends, and support groups available to me. I have faith in the decision that you make being the best in my interest, in my best interest. Thank you.
Thank you. Well, I don't just have to look at you and make sure that your rights are protected and all of those things. I also have to look at the public interest and what's in the best interest of the community. I appreciate your statement, Ms. Chamberlain. I read Ms. Landgraf's sentencing memorandum, and I'm just going to start with that. I read it. I was shocked. I mean, who is sitting in that chair right there in orange as to who I have in black and white right here? Unbelievably, completely different. 2 completely different people. And I don't know what led you or brought you to that chair. I do have an idea because of this case, I had to get to know your divorce and what happened there. I got to know that, and through this, you were married 30 years or almost 30 years. You have 2 grown, apparently wonderful children. And you are a grandparent, and it sounds like, and what I'm able to gather, I can read between lines too. You had a really good marriage. You did a lot of great things, ups and downs, I'm sure. Marriage is ups and downs. But together, you were a great team because you built great, wonderful things. You were a businesswoman. I don't know the level of college you had, but I can tell you, seeing you there and knowing what conduct you have done to get you here, and then knowing where you were before, I'm going to tell you, you are a smart woman. You are a smart woman who has done stupid things. And I believe it has something to do with your heart. I'm not discouraging you. I can't tell you who to love and who not to love and who to get into relationships with, but you seem to have had a great life, doing great things, being a very strong, independent woman who can accomplish so much. I didn't know you did that. You and your husband built that winery. It's amazing. But for the fact of probably the divorce and that downfall, you most likely end getting in and going the opposite way. And you most likely probably would have built the building in Grantsburg into a thriving business. I don't know what led you down the road to substances. I have ideas, but it makes me sad as a person and as a judge to see somebody who was thriving so well in life and doing well and hit a huge rough patch. There's a rough patch there. Because in reading the things that I had to with your divorce, whatever happened in your marriage and how you, happiness, not happiness, fights, not happiness, the divorce was tumultuous.
It was brutal.
That's what I gathered. And so it's really hard, I'm sure. It's like a death. And it affected you, it affected your children. Don't let it destroy you. And I know it's hard to see, and for a person that you looked in their eyes and you said, I do forever, and you loved him immensely, to go from that to where you were in your divorce, I can see that pain. And that is trauma. Absolutely no excuse, no reason to fall into substances, absolutely no reason to start to build a lab, for substances. I'm going to tell you, I never paid attention or heard of dimethyltryptamine until this case. But I'm going to tell you, once I heard dimethyltryptamine, DMT, I now hear it in shows, and I hear it, and I say DMT. I'm sure I've heard it before, but it never clicked because I've never had to know what it was before. I'm glad to learn about it. I knew about it to the extent of it's all legal things you can buy on the internet. You can do those things, but it's once you start to manufacture it and bubble it and then make it into the crystals, that's where it's illegal, because it's a substance. It's an illegal substance and it's a lab. I can see that this has had a significant impact on you and your whole life. I believe Ms. Landgraf stated you are going to start anew. You have to start fresh now. You don't have clothing, you don't have furniture, you don't have anything because you were arrested from that building. You were brought here. It's been 344 days. And now you're a convicted felon. Again, that pains me as a person and as a judge to know that somebody who did such great things in her life got to this place. And I'm hoping, and I think it's going to happen, that because you've had your epiphany in custody, you've had your time to become sober and have the substances, all of them work their way out of your system. I'm confident that you are going to have even more epiphanies. You are going to grow and you are going to become somebody else who can do what's written in the black and white from the memorandum versus the black and white of the criminal complaint. I'm just going to say, no man, no love, no anything is worth your self-respect, your criminal record, your life.
I made the choices. They were my choices. And I just didn't want to feel.
I understand that. I get that.
And I know that it was wrong.
You are owning that. I understand that, and I get that. It's just hard for me to read who Laura Michelle Chamberlain was And to think that she would have made those choices even with the impact that her life was having, but for other factors. And I understand the heart, I truly do. But I also understand strong, independent women and those that need to continue to rebuild and look out for themselves. Because it's your life, it's your children, it's your grandchildren. I don't think that the communities would be hurt or at risk if I put you on probation. You have no criminal history. Again, this was the worst, most terrible time in your life, and you made the worst, most terrible choices. So what I am going to do is I will adopt that deferred judgment of conviction that'll be in place, and you must do all of those things. I'm going to tell you the number one reason I see the state asking to terminate and revoke that agreement is, and to have me sentenced on those felonies, is the payment of $150 within 60 days. Get that done.
Yep.
Get it done immediately. Do your AODA assessment and make sure, even if you have to hand walk the documents to the district attorney's office, that they have that documentation. Because I don't want to see those little things. They're not little, but they're little compared to other factors. Those things be the reason why you face going to prison. With regards to the possession of methamphetamine, I will follow the recommendation, 3 years of probation. Generally, I would think, and I have in other cases, that 3 years, that's a lot of time to be put on probation for your first criminal offense. But this is a doozy. This is your first criminal offense, and they're felonies. And you obviously need some help. And it's not, it's unfortunate that it has to be in a way that the Department of Corrections will be watching over you and the state will be watching over you. But I want you to get back to who you were. Again, before this memorandum, I would never have guessed, just knowing the black and white of the criminal complaint, okay? You deserve to be back to Laura that you were meant to be, that your family deserves you to be. And they want you to be. So 3 years of probation. I'm not going to do a withheld sentence because I'm going to tell you if she's going to be revoked, she's going to be revoked. And then she's going to be sentenced on the other matters too. Because, well, I'm second guessing that. No, I will do a withheld sentence. Because if you are going to be held and it's looking at being revoked, then you will be in custody, and it's not going to matter because I'm going to have to hear arguments for 3 serious felonies. And quite honestly, I'm not prejudging or pre-saying anything I'll do, but all same date, same time, same place, same things. So I can't see why there would be, at least in my mind right now, consecutive sentences. Conditions of probation. Absolute sobriety, that AODA assessment and the follow through, a mental health assessment and follow through. You need to work through some of that trauma. Regular testing, no alcohol, because that's absolute sobriety. Gainful employment. And I am going to add 20 hours of community service. Done good for your community, and from all respects, I would think that you were respected from the community, and perhaps this could be something that has let them down. So just give back a little bit. So 20 hours. I don't think that's too much. I think you can do 20 hours in the first year. All right. 343 days of jail credit.
Judge, I think she gets credit for today because she's not going to be,
I can pull up the case.
oh,
Court of
okay.
Appeals case says you do not count date of sentencing.
Oh, okay. I thought that was only if like you're continued to be in incarceration because the DOC counts that.
I don't believe so. I don't know. If you want to show me, that's fine. Otherwise, if she's revoked, I'm going to tell you, DOC is going to tell me I need to add days or minus days or
Right.
all of those things. So. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. The jail make sure that they have that. At least with the methamphetamine, you have the ability to request it be expunged through a written letter to the Department of Justice. With the other two hanging out there, they kind of have to wait to see. $518 in fines and fees for the possession of methamphetamine. I can't recall if it was asked or stated that she does better with her mom and to live with her mom. Was that even a request?
I can't live with my mom. She
Okay.
won't let me.
What's your plan?
Well, I will stay at my mom's for a little bit, but once I have a vehicle to find a job, find a place to live.
Okay, all right. Well, I will say that the $518, I'm just gonna say DOC can collect that. We'll worry about that later. I think that covers everything. Oh, if the deferred judgment of conviction gets entered, okay, not right. Oh, yes, no, you have been a possession of methamphetamine. Again, let you know, no voting until your civil rights are restored. No longer able to use or possess a firearm for life. So hopefully you weren't a hunter. Mr. Schmidt, what am I missing?
Nothing from me.
Ms. Landgraf.
I've already went over her post-conviction rights with her, so I don't think that there's anything else.
All right, well, good luck, Ms. Chamberlain. You must report to probation immediately when you are released from custody. I need an address. Do you know your mother's address right now?
2057 244th Street, St. Croix Falls.
So you report to Burnett probation. They'll transfer it to Polk. Do you have a telephone number?
No,
You need to get a new phone?
yes,
Okay, and once you have a new telephone number, update the clerk's office as well as probation. If you move from your mother's address, not only do you have to update probation, you have to update the clerk's office here, okay?
yes.
All right. Nothing further than we are adjourned.
Judge, actually, one thing, her phone was compensated by law enforcement, but there was never a search warrant done. There was never a forfeiture filed to keep that phone. So I believe that it should be released to her. I just want to make sure that
That's
she,
fine.
that she can get her phone.
I have to order it on the record all the time with every sentence.
That's fine.
Okay,
With every
Mr.
conviction,
That's a
you have to
Mr. Schmidt question. He can release it.
Have her go to the sheriff's office and ask for it. They'll send something to me and I'll say, do it, and then she can set the time to pick it up.
Thank you.
All right, then we are adjourned. Thank you, Mr. Oyot.
And my next contestant is
We will go on the record in the matters 26 CF 08, 26 TR 03, State of Wisconsin versus Jonathan Oyot. The state appears through District Attorney Kevin Schmidt in person. Mr. Oyot appears in person in custody with counsel Renee Landgraf. We're set here today in this matter for a waiver of preliminary hearing and a plea and sentencing. First off, Mr. Oyot, did your attorney go over with you what it is to have a preliminary hearing?
Yes, Your Honor.
Do you understand that the burden is on the state to prove a felony was probably committed and probably committed by you?
Yes, Your Honor.
And do you understand that by waiving your right to a preliminary hearing, you are agreeing the state can meet that burden?
Yes, Your Honor.
Do you understand at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, call witnesses to testify for you, produce evidence on your behalf or possibly discover things about the case which could include defenses, but you're giving up those rights today.
Yes, Your Honor.
You understand that if the state were not to meet its burden, I could reduce the felony to a misdemeanor or dismiss it altogether, but you're giving up that right today.
Yes, Your Honor.
Do you understand that once you give up the right, it is forever and you cannot get it back?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing.
Yes, Your Honor.
All right, Mr. Schmidt, information?
I filed the information. It mirrors the criminal complaint.
Not guilty pleas will be entered on your behalf as to all counts right now, but the parties have reached an agreement and wish the court to proceed with it. Ms. Landgraf, what is the agreement that's been reached?
Your Honor, I did file a plea questionnaire to document 22. My client will plead guilty to count 1, possession of methamphetamine. The joint agreement is a withheld sentence, 3 years probation. The other 2 counts and the accompanying traffic for citation will be dismissed and read in.
Okay, Mr. Oyat, that's the agreement that you reached?
Yes, Your Honor.
You're 47 years old, 10 years of schooling. You have an HSED and you can read, write, you understand the English language.
Yes.
Did your attorney thoroughly go over what the state would have to prove as well as the maximum possible penalties?
Yes, Your Honor.
No mental health treatment and no medication, alcohol, or drugs.
No.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that first page. Did your attorney thoroughly go over those rights with you?
Yes, Your Honor.
Do you understand them completely?
Yes.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you need me to go over those rights with you in any more detail?
No, Your Honor.
Did your attorney thoroughly go over that plea questionnaire waiver of rights form with you?
Yes.
Is that your signature?
Yes.
You understand everything on that document?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that you're pleading guilty to a felony, as such you will no longer be able to use or possess a firearm for life?
Yes.
No longer able to vote in any election until your civil rights are restored?
Yes.
Do you understand the state would have to prove on or around January 1st, 2026, you possessed a substance? The substance was a controlled substance, methamphetamine, and you knew or believed that substance was a controlled substance, methamphetamine. Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or 3.5 years of incarceration, or both?
Yes, Your Honor.
Do you understand that I'm not bound to follow any recommendation that the parties have reached?
Yes, Your Honor.
Said differently, I do not have to follow a recommendation for probation, and I could sentence you all the way up to the maximum penalties, which could be prison.
Yes, Your Honor.
Do you wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney,
Yes.
particularly the probable cause section with those facts that are alleged and why they charged you with those crimes?
Yes, Your Honor.
For the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did possess methamphetamine
Yes.
and you knew it was methamphetamine?
Yes.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Ms. Landgraf, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you, Mr. Oyat, for you to plead guilty?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
She answered all of your questions.
Yes, Your Honor.
Has she looked at this matter thoroughly?
Yes.
Are you satisfied with her services?
Yes.
Any questions for the court or for your attorney before I proceed?
No, Your Honor.
As to count 1, possession of methamphetamine, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. The remaining counts in the TR matter will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Possession of controlled substances is not a crime of moral turpitude. It is something that is a medical condition, or it results from a medical condition of substance abuse, which should be treated. I think this is one of those cases and the court should follow the agreement. Thank you.
Thank you. Ms. Landgraf?
Thank you, Judge. Mr. Oyat's already on probation right now. He's actually on appeal hold, so he will not be released today. Fortunately, his agent, Amber McDowell, she is setting up inpatient treatment for him, so he will be going to inpatient treatment directly from here, which is kind of why we wanted to fast track the plea agreement so he could just be ready to go to treatment whenever. And I also believe that as part of in the ATR for his current probation, he will be referred to the Burnett County Drug Court program, and Judge is shaking her head, so it looks like she already knows that. So, I mean, inpatient treatment and drug court is no doubt the best course of action for Mr. Oyat right now. Thank you.
Thank you. Mr. Oyat, is there anything you want to tell me? You want to let me know? And we go way back, so fill me in.
Yes, Your Honor. Like, me as, pretty well in and out of here just because of my addiction, I believe, that, I could do prison, but
You've done it before.
yeah, and look where it's gotten me, when Amber came up with the suggestion of drug court, I've never done it before, but I think that's where, structure, is what I need, structure in my life, because I get too much, I guess you say, complacent, and it just ends not well. And then I guess my emotions always get the better of me, I'm just tired of being tired of it, tired of that life. So I'm willing to do anything or whatever, any lengths I got to go to get my life back, rather than because, it's either I'm going to die or be incarcerated for the rest of my life because of my addiction. That's just truth.
That is, Mr. Oyat, and it's
sad.
It's sad. It is sad. And what I also find sad is the fact that, I mean, when I say we go way back from, I don't want to say my very first day on the bench, but my first year on the bench is when I first met you. And Mr. Oyat, you can be scary. You can be scary when you're under the influence of illegal substances, when you have had alcohol, especially because in what I've learned from you is once you have a drink, you have all of the drinks and you use all of the things. And that's why I say you become scary. I've had, again, it's weird because I want to say the pleasure, displeasure of knowing you for so long. And I know your son, and I know your daughter, and I know that you're a grandfather, and I know you're going to be a grandfather again. And I know all of these things. And the thing about you, Mr. Oyat, is when I say you can be scary, you can be. I don't know personally. I just know what comes across my desk. But you also have a heart of like a kitten. You have a sweet and kind and gentle soul. You let the devil in. You do. And I wish that you would figure out a way to take control of it. You are able to take control and to grasp many things in your life. You are very strong, stubborn, all of those things. If you could only figure out how to take control of that aspect of your life, you could go far. You could. Once you figure out how to control the methamphetamine and the alcohol and not let it control you, Mr. Oyat, I won't see you in that chair anymore. I want to see you on a rocker in a front porch with your grandbabies on your lap, reading a book, drinking an iced tea. Okay, that's what I want to see. I don't want to see you in orange anymore. I've sent you to prison once or twice. I could send you again if you don't change. I don't want to see that, Mr. Oyat. And I don't want to see the continued cycle with your family. I want Jacob to do better. I want Ashley to do better. I want you to be there and be able to show them, look what Dad can do. Look what I can do. Because if you can do it, Mr. Oyat, anyone can. You just have to use that willpower of yours to actually decide to do that. In this case, in which I'm sentencing you, and even taking into account your history and all of those things, this is serious because it's a methamphetamine case. It's a felony. It's not one of the cases where you're out and you're selling drugs or you're using firearms or you're doing other acts, okay? So in looking at this matter, I think probation is appropriate, okay? You're gonna go to treatment and there are gonna be certain things. I'm gonna do the 3 years of probation and here's why. I think you need 3 years of probation because you're going to, part of the condition, a condition is going to go to your treatment that DOC sends you, and you must successfully graduate from that treatment. No running away, no causing havocs. If you're feeling that trauma and that anxiety and frustration, what do?
Talk to somebody.
You don't react,
Yeah.
right? You have to look for somebody and talk to somebody and talk it out because you're going to graduate this time, Mr. Oyat. You're going to, and that's a condition. Another condition is that I'm ordering that you apply for treatment court. If accepted, which no doubt you will be, you successfully complete that.
Okay. Dave Hatch came, I think it was last month. I think we did some paperwork.
You already did it. You already applied and did those things. I have to state it on the record.
Okay.
So that's why.
All right.
But yes, and so that's why I know that about the treatment court, those things, you do need that structure. It's a lot of work, Mr. Oyat. It is a lot of work. I'm not going to lie. It's a lot of going to meetings. It's a lot of going to groups. It's a lot of going to therapy sessions. It's a lot of coming here to court. It's a lot of work.
That's what I need.
You're going to give me pushback. I'm going to push harder. But in the end, Mr. Oyat, because you have to want it, you have to want it. In the end, you're going to graduate and you're going to be a role model. That's what you need. Idle hands are the devil's workshop.
Yeah.
All right, they are. So at least this is going to give you more structure and more things to do.
I'm 3 tests away to getting my high school diploma.
Excellent.
Yeah. Pretty excited about that.
I'm very glad to hear that. That is great. There's something else I was going to say, and something probably about your past. Yeah, apparently it wasn't so necessary. Absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. Regular testing. You'll have to have some gainful employment once you're in treatment court. I need your DNA. The jail will make sure that they have that. You have the ability to request it be expunged through a written letter to the Department of Justice. Yours is already in the system. You've been to prison a long time ago. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. $518 in fines and fees. That can be paid to probation, not here. Report to probation immediately. Let them know about the sentence. They do, but just call them and let them know. Ms. Landgraf, you wanted to say something?
He's been on a cash bond since he was arrested, so I believe we've had 57 days credit. That does not include today.
All right, thank you. 57 days of credit if you are revoked. I'm not doing a withheld sentence. That's where I'm getting at. I'm not doing a withheld sentence. I can't if you're going to be in treatment court. So, because I'm a one judge county. So what I'm going to do again, this isn't the most serious. I know it probably should order that you go to prison if you're going to be in treatment court and those things, but this isn't a prison case to me. even with all of your criminal history, even with knowing those things. It's just not. So I'll do a 1-year jail sentence. That's a big enough hammer over your head, I think, right? Because who wants to spend almost a year in jail?
Not me.
Exactly. So imposed but stayed. I think that covers everything, Mr. Smith.
Nothing from me.
Ms. Landgraf?
Already covered post-conviction, right? So I think we're good.
Noah's going to tell you something good, Mr. Oyat, but I look forward to working with you.
Look forward to it.
You're adjourned.
Thank you, Your Honor.
Kevin Dittmer versus Christina Litmosky and Joshua Bell, 25-04813 appearance. State your name for the record.
Pardon me?
State your name for the record.
Kevin Dittmer.
And your name?
It's Christina Frisch.
Christina,
Frisch,
your name changed?
21 years ago,
How do you spell your last name?
Frisch.
And your name, sir?
Joshua.
Okay. This was a small claims hearing. Or must have been an appeal. Let's see what we have here. Okay, so you were suing them for trash to your home and 2 months rent?
Yes.
Okay, tell me what happened.
Well, here I've got a packet for you, actually.
Tell me what happened.
Well,
This doesn't work that way in court. You don't just hand me a packet.
I got
You gotta tell me what happened.
I rented one of my properties to the defendants.
Which one did you rent to? Both or one of them?
Both.
Okay,
And that would have been July 1st of 19. They moved.
July 1st, 2019?
Yes, they moved in.
How much was the monthly rent?
$11.85.
Okay, and so they lived there for how long?
Till March of 22.
And did you have to evict them or they vacated on their own?
Kind of a combination.
How's that?
Well, I chased them continuously for my rent money. Every month I chased them, and sometimes it was 2 months or 3 months before I got my money. I got kind of tired of that.
Did you ever file an eviction?
I did not.
Okay, so you did not have to evict them, they ended up just leaving.
Well, yeah, eventually they did because of a pink tag. The house was pink tagged because of no inspection.
Okay, when did the property become pink tagged?
I believe that was December of 21.
Due to lack of inspection, you're saying?
Yes, yes.
Why wasn't there an inspection?
Well, there wasn't an inspection mostly because every time I would bring up the thing about inspections, they put me down on that. Nobody coming in this house. Nobody's coming in.
Okay, so they denied you access, is what you're
They
saying?
refused to have the place, and it all started in 2020. It should have been inspected 2020, right around COVID time. And I remember distinctly, she came across the street and said, "Nobody's coming in my house. I have an autistic child, and I'm not having somebody with this COVID thing come in my house." So it never happened. Well, then code compliance came down on me because it wasn't inspected. They didn't want it inspected, of course, and so I told them at that time, plus the fact that they were 3 months behind in rent at that time.
So this is in 2020 or 2021?
2021.
So when they became pink tagged, which you said was December 2021, they were 3 months behind?
Yes.
Continue.
I chased them around to get my money, and basically told them, obviously you can't afford this place, so you need to find a place to live. So chased, and I explained that I'm tired of chasing you around for my money. Now's the time for you to find a different place that you can afford. And I have text messages to, support all of that. It took them about 3 months or so after the pink tag to get out. So consequently, they didn't pay any rent, February or March rent. They finally left, I believe it was March 15th or 16th, somewhere around there. I have text messages to show. And once I got in there, then I understood why they didn't want me to come over there to collect rent. And I understood why they didn't want me to come in that house. And I understood why they didn't want to have code compliance come in there, because the house was trashed. I mean, I have pictures.
What is the evidence that you have?
Well, I have a timeline for, how I did with that house before they moved in.
When you say how you did, you mean like maintenance of the house?
Yes, well, yeah, it started, basically, when they moved in, the house was for sale. But I had gone through back surgeries and I had gone through a whole lot of stuff to where, I wasn't able to do the rent thing anymore. So I put the house on the market, and I put it on the market in 17 after I put it back together from the previous tenant. I put it on the market in 18. Let's see, 10/1 of 17, I put it up for sale. And I have all of this for you, if you would like to.
Okay, continue to tell me what else you have.
Well, so I put the house up for sale on October 1st of 2017. And then I threw my back out on 3/16 of 18. And I was in bed for like all of 18. I mean, like 8-9 months I was in bed. I had to go to doctor's appointments, and I had to do injections, and I had to do this and that, and, all of this stuff. And then they finally decided to do back surgery. Well, I got my first back surgery on 2/22 of 19. The house was for sale at that time. Had been for months. My dad was actually taking care of, mowing the lawn and all that kind of stuff, and showing the house if there was, if that opportunity arose. And then I went down again after, I don't know what it was. It was probably a month after the first surgery. I went down again, and so then I had to, go through all of this other, stuff again, doctor's appointments and all this, and then I had second back surgery on 6/21 of 19. So 4 months, almost 4 months exactly from the first back surgery. And then let's see, 2 days after my second surgery, a friend of mine called me and said that she had a friend of hers that was looking for a place to let. And so I said, well, I can check it out, because it's not selling. I'm the market's not good for that, and so and I still had to make payments, so I had to do something. So I decided, okay, I'll check these people out.
Okay, so they moved in. All of those things doesn't help your case. This just tells me how we got here.
Right.
Okay. Show me how they transfer property.
Okay. So. Well, pictures.
Okay. You can go through what I'm going to see in the pictures.
Okay. You're going to see.
Show me, open the pictures. I want you to go through, because did you give them a copy of these pictures?
They've seen them.
Did you give them a copy of these?
I did not.
Okay,
But
so as you're going through, you're going to explain what I'm going to see.
Okay, these are befores.
Okay, thank you.
These are afters.
Got it. And so what areas of the home am I going to see here?
Well, this is kitchen. This is kitchen here. And kitchen.
Okay, and so what you're saying, okay, you can keep going. What you're saying, that this is more than just normal wear and tear.
Oh, if you look at these pictures,
You can explain to me what I'm going to see. That's your job to explain what I'm going to see.
Okay, well, trash everywhere. The floor destroyed, brand new floor, destroyed.
The flooring was destroyed how?
Ripped up. It's in the pictures.
Got it.
The cabinets, horrendous, filthy. Everything was filthy. The entire kitchen was filthy.
Now when you I can understand filthy, but was it cleanable or was it like things were
Everything in the kitchen had to be
beyond
repainted.
repair? I'm sorry?
Everything in the kitchen had to be repainted.
Okay.
Everything, the cabinets, the walls, the ceiling, everything in the kitchen had to be
Okay.
repainted.
So those are pictures of the kitchen and more
here's-
pictures of the kitchen?
This is more of the kitchen.
Okay,
This is more of the kitchen.
okay.
And then we go into the living room, dining room. I have date stamps for these pictures.
Is that what the other little card is?
That's what
The
these
date
little
stamp?
ones are, yes,
Okay.
these are date stamp. But here, these are pictures of the living room,
Before, is that what that
living room,
is?
dining room, yes, before's on the top here, befores and afters,
Okay, very good.
okay? Cat box. They were not allowed to have animals in that house, period.
Okay, that was in the lease?
It was. I can show you that too, I have a copy of that. for
I
you.
would appreciate that.
You want that now?
When you provide, that you can bring it, yeah.
Okay. And then the carpet, the carpet was toast. I mean, there was cat feces all throughout the house. Every room, every wall was sprayed. Every wall had, every square inch had crayon on it. You know, as far as a small child can reach, on every wall, in every room. So the carpet was toast. This carpet was new at the time. So then we get into, that's the dining room. Then we get into the office. Same thing, trashed. There was trash everywhere. There was cat feces. There was spray on the walls. It was nasty.
Spray, when you say spray, what do you mean?
Cats, you know how they do?
No, you have to, oh, you mean, they sprayed, the cats spray the walls?
Yes.
Got it?
And it, I mean, it stunk so bad that the person I had come in there to clean the place had to wear a mask.
Okay.
And it was nasty. And actually the guy that I had come and help me to get the plumbing situated, also allergic to cats, and he really had a hard time. So this is more of, this is office, you know, all the stuff that was piled in there and the carpet was toast.
This is what's piled in the office when they moved out?
Yes. So this is more stuff in the office. They did something to the carpet on the stairs, so they replaced the carpet on the stairs with, you know, some cheap, didn't even match carpet. But the whole staircase walls dented, smashed. The railing, the handrail here was ripped right off the wall and hanging, laying on the floor. And that's in this picture here. Then we come up into the first bedroom. First bedroom, before pictures, after pictures. Holes in the walls. You know, just tons of stuff, trash everywhere. Carpet was toast.
These pictures in the bottom
This
are
is-
what is there after they moved out?
Yes.
Okay.
Then we get into the yellow bedroom. Well, that's because it's yellow. Yellow bedroom. Now, I'm not seeking for, you know, I'm not trying to charge them for this replacement carpet because that carpet actually was, it had been there for a couple of years before they moved in. So I'm not concerned about that, even though it was still in good shape at that time. And you can see that by the pictures. And then afterwards, there's screens, there's ripped screens in the windows. The carpet is toast, stains everywhere. All the walls had crayon or filth on them. And again, a bunch of trash. And then the master bedroom, again, befores, afters, bunch of stuff left in there. The carpet's trashed. The ceiling fans, none of them had globes on them anymore. And there might not even been light bulbs. I think they might have took all the light bulbs too. But they trashed, you know, there's an entrance to go up to the attic, and that entrance was absolutely trashed. The whole wall there, as you walk into the entrance, the back side of that wall was the bathroom. And they had that so destroyed that you could see the bathroom plumbing through that, and you couldn't see that before. And then, you know, again, trash. The attic was full of trash. I don't have any pictures of that. But the hallway, same thing. Here's, you know, befores and afters. You know, there's an alarm system in the house, and the cables were ripped from where they were pinned into, you know, areas. They were ripped, just hanging. You know, the floor was toast, the carpet was junk, and that screen, the window was missing, the storm window was missing, and there was no, and the screen was ripped for the hallway. Then you get into the bathroom. They ran off with the shower head, no shower head. It's filthy. Toilet was absolutely garbage. You know, those toilets were brand new before they moved in, both the upstairs and the main floor bathrooms. The toilets were brand new. This is what was left. The shower doors were ajar and just a mess. You know, they're sliders. They were all jacked up, and you know, so that required a bunch of hardware. I did end up getting them repaired.
Okay.
But you know, there again, and more trash. And the floor was also, the tile in the floor, which was new, was also ripped up, and the trim, all of the wood trim behind and around the toilet was all ripped off the wall also. Then we get to the basement where they were growing weed when it wasn't legal to grow weed. They left my basement in complete disarray, bags and bags of weed, trash bags full of weed. They took all of my pantry shelves in order to build their little grow room. They took all of my shelves out of my pantry. So, and who knows what happened to the boards. And then all these trash bags, that's all weed. Weed on the floor. Weed, trash. Again, you know, no boards in the pantry. Got the uprights, but no shelves. And you know, more trash everywhere. The whole basement was trash. And then while we're on that particular area, the upstairs bathroom, they had put something, I don't know in what drain, but in some drain, whether it was the toilet or whether it was the sink, or it had to have been the toilet or the sink, more likely the toilet. What happened is every drain from the upstairs bathroom, every drain went to the downstairs bathroom, and it has a wall sink, and they had, and I'm sure this was intentional. The wall sink has an S-trap that goes into the wall for the drain.
Okay.
The S-trap was full of what appeared to be concrete. There was no getting it out of there. And so what happened was everything that came from any drain on the second floor from the bathroom, whether it was the shower or the toilet or the sink, all of those drains, if you ran water through them, it would go to the main floor wall sink, is where all of this would go. It wasn't going through the system and going to the basement into the, you know, then to the road. It was going into that sink. And I have a picture of the bucket that they had sitting next to the toilet. I'll get to that. They had sitting next to the toilet, or next to the wall sink. They had a bucket there, so they knew it was doing this. Consequently, I had to have a guy a maintenance type guy, and he came over and had to take the toilets off. Well, the upstairs toilet, I had to take the toilet off, tried to snake it. That wasn't working. My cleaning person was, downstairs doing everything, that she could do. She couldn't do anything upstairs because if you ran water, it was trouble. So all of this goes to the second floor sink. Well, so we can't. Tried the snake first. The snake isn't clearing it. So he tried CO2 after that to push pressured air into the system to see if that'll free it up. That didn't work either. So then had to go follow the stuff.
Something's blocked. Did you ever figure out what blocking it?
Yes. A perfume bottle and a big scrunchie, hair scrunchie. And I have pictures of that also. And all of the plumbing had to be cut out in the basement in order to get to it. All of the drain plumbing, I have pictures of that also. The drain, all of that had to be replaced.
Okay.
So, to the tune of $1,044.04 is what the drain situation
From the scrunchie and the perfume bottle?
Yes.
Okay.
And then we go to, this is the attic. More trash. And this is a roof vent in the attic to keep the roof from getting too hot. It's an automatic fan. It's not even hanging anymore. Well, it's hanging, but it's hanging by wires now, or was. And they ripped down all of the insulation that was in between, trussing in the attic. All of the insulation, it was all fully insulated, but it's all ripped, torn up, destroyed. And there's, and there's another picture of the plumbing on the backside of the toilet, or the tub that I was talking about too. And then, more trash. And then we go into the back porch. This is the way the back porch was left. Trash, trash, trash. You couldn't even walk through there. There was appliances, there was beds, there was trash piled all the way to the ceiling. And it stunk. All of that had to be removed. More of the same. Outside the house. All of the stuff, this is all around the back porch. More stuff that I have to do something with. Then we get to the garage. Same scenario, more beds, more stuff. And it's trash. Here's the sink, the downstairs sink with the bucket sitting by it, and some sort of a snake that they were trying to do, maybe, I don't even know. There was a chandelier in the dining room also that was not hanging the way it was supposed to. All the wires were pulled out of it, and that was $60-some to repair that. Here's all the carpets. Every carpet had berry stains, cat stains, whatever stains. The carpet in the entire house was ruined. All of it. I mean, it's disgusting. And it was, and a lot of that carpet was new. The dining room, living room, and the front bedroom, it was destroyed. And I took pictures of also the back sides of the carpet so that you can see the nasty on the back side. And all the stains, and just destroyed everywhere. Back side of the carpet, destroyed. Consequently, what that did was it had hardwood floors. So when you don't clean up your mess and it sits on that hardwood floors, it destroys the hardwood floors. This is all of the people that were living there. According to the lease, they were allowed 5 people. There was a zillion people living in that house. I've got names of a whole bunch of people here. I took pictures of their mail before I gave it to them. This is the hardwood floor underneath. These are the stains that it did to the hardwood floors. Now, I had the floors redone. I'm not asking for that. What I'm asking for is to pay for the carpet. And then I put that towards this. So, you know, this is the after effect. I had the floors redone, but see, it cost me $4,800 to have these floors finished.
Oh, I'm sure.
And that was without repairing the stains. If they would have repaired the stains, it would have been another $2,000. And those stains were not there prior to them. So there's more finished.
That's after you replaced it.
Yes. And like I say, I was $4,800 to do that. Now this is the kitchen floor, or no, this is the office floor. I had, because of stains in certain areas, I couldn't even refinish them. Like, they couldn't be refinished. I had to do laminate. I had to go over top. So this is the dining room, because that's where a lot of the cat box was. The cat didn't use. And then that goes out into the living room, which was refinished. And then this here is the start of the office with the laminate, and then this is finished. This is the kitchen floor and the starting of the laminate to go, because, you know, it was toast. So I have pictures of, you know, finished product there also. So those are my.
Those will be the plaintiff's exhibit.
We'll call those.
1-1.
I have.
Plaintiff's exhibit 1 for that.
Okay.
Any objection to his exhibits that he just went through?
I mean, the cat stuff wasn't all through.
No, I'm not asking you to explain. I'm just, the basis of your objection would have to be, that's not the apartment, or it's not the.
I mean, the before pictures are 2 years before we moved in, not right before.
He said they were before you moved in.
Yeah, that's the only thing I got.
Okay, nonetheless. We'll mark it, we'll get the book. And then you also had a copy of the lease, sir?
Yes.
Okay, so you're suing for the damages that you said were done to the property that needed to be replaced?
Yes.
And how much was this?
Well, we're talking about 14 grand, but I'm not, you know, obviously I'm in small claims court. I'm asking for $7,000.
Okay, and
because the damages are far exceeds.
How much but you have to tell me what they were for.
Okay.
I know you mentioned the plumbing cost, how much?
The plumbing was $1,044.04.
$1,044.04 for the plumbing?
Yes, ma'am. My cleaning, I paid her, she was there for 19 days to clean the disaster. I paid her.
What about all the leftover like stuff? Like the cleaning lady is the one who's cleaning out the personal items that were there? Because it looks like there was a lot of stuff there.
Oh, there was tons of stuff.
Okay.
Tons of stuff.
Who's clearing all that out?
Well, I took 11 and a half truckloads. I have a Ford F-150 with an 8-foot bed. I took 11 and a half truckloads to Granger's.
And there's a bill for that.
$345 was for the truckloads. And then
$345 for 11 truckloads.
11 and a half truckloads. That's a pretty good price, really.
That's what I was thinking.
Like I said, I'm not trying to burn anybody here. I'm trying to get what was lost.
Okay, so you said you had to replace some plumbing because of what you believe they did intentionally to the property, and the search yielded a perfume bottle and a scrunchie.
Yes, and there's a picture of that.
Okay, and then the carpets.
Carpets were absolute. Well, you have pictures of that also.
And so, what are you saying the cost for?
Well, so carpet, I've got an estimate from J&J. They do flooring, and I had them.
You have it there.
Yes.
Oh, okay.
It's in your packet. Actually, this is your,
I was
this
gonna say
is
what
your
packet?
packet.
Got it.
So if you want this, I have another one.
Okay.
So if you
got
can,
it.
you know, so you can kind of
You
follow
can grab
along.
that. Thank you.
You can kind of follow along
You
as
can
to
give
what
me
I'm-
that, and then I'm gonna go off the record real quick because I can get these other 2 cases out of the way while we finish yours.
Okay.
Let's see. Okay, back on the record. For you, Mr. Dittmer, and then I have your packet here. You have,
I'm on exhibit 2. I have labeled on the top is what we're talking about, the dollar amounts. I've given you everything I could possibly come up with. Evidence, evidence, evidence.
okay, this was the timeline that you had. Okay, this is what I was looking for. This is what you typed as exhibit 2. We'll use it as exhibit 2. It's going to be itemizations of what it costs for you to get things done.
Yes,
Okay, so to replace the flooring that was damaged, you had carpet, laminate costs, and then labor for a total of $4,414. You've made it clear on this record that you're really looking to get the carpet replaced because and not the other thing.
I didn't.
Or you want damages for the carpet.
Yes.
Okay, and then there was painting costs. You said paint, drywall and mud, and then the labor.
Yes, there's receipts for all of the material there, as far as drywall and kills and paint and drywall mud.
Got it. Okay, and then you have cleaning. This is the cleaning lady. So you
The
said had to
cleaning- yes,
come
the cleaning
19
lady.
times, you said? Tell me more about that.
She, when she came in, the stench was so bad that she couldn't even come in the first day. She had to go get a mask and you know, come back the next day with a mask.
So it took her 19 days. to clean it, is what
19
you're saying.
days. Yep, and once you see those pictures, you'll understand. 19 days, you know, and I can't tell you exactly how many hours every day, but I paid her $1,200
Okay,
at $10 an hour.
okay, so, but it took her, got it. So it could have been an hour a day, sometimes hour and a half, maybe.
Yes,
Got it,
more
okay.
likely 5 or 6 hours.
And then,
Because she also helped with cleaning of to get the crayon off the walls, because the painter couldn't paint the walls with the crayon because paint doesn't stick over crayon. So all of that had to come off. And so there's a receipt there, I think, for a whole bunch of, you know, magic erasers and that kind of thing. But the cleaning person, she's the one that cleaned all those walls also. So there was a lot of time.
okay. And then, let's see,
And then
trash pickup. That's what you told me about from the Granger.
yes, there's the 11.5 truckloads, and then there was
Appliance disposal and then mattress box.
yes, they get $25 a piece for a mattress or a box spring,
Okay,
and they get $40 a piece for an appliance.
okay,
So I had 2 appliances in the back porch. I had 6 mattresses in boxes.
okay. And so then you're saying you're suing for rent because they vacated.
They well, they didn't vacate until the middle of March or close to the end of March,
But had not paid rent.
but had
during
not
March.
paid for February or March.
Okay. And then your proposed exhibit 3 would be the rental lease.
That's the lease, and all of the bullets that I have that are marked, those are all things that they went against. They didn't uphold anything that had to go with the lease, as far as, you know, the people there, the cats and dogs, and you know, and you know, they received the place. I read this lease to them when they signed it. My dad showed them the house because they got to see the house like 2 days or 3 days after my second surgery. And my dad had to show them because I was still in recovery.
Okay, but you were allowing 5 people to reside at the home.
Yes, it's 2,000 square foot. It's a big house.
No, I'm just noting what the lease says,
Right.
and no cats or dogs.
Yeah.
And it doesn't sound like you were concerned about the 5 people were, you didn't make them sign a part of the lease. You just, it's her, and Mr. Bell, correct?
Her and Mr. Bell, and she said that she had a couple of kids that might be there once in a while, and they had another child.
Christina, I didn't mean to call you her. It's Christina and Mr. Bell.
Yes, she has an autistic child also, and he was with them.
She has a child.
Yes.
As well, correct? Okay. Okay, and then what is this receipt for?
That is everything, most everything.
What it cost you
As I was
to
going
repair.
through, yes, as I was going through, I was making note of everything that
Got it.
needed attention.
Okay, so then the rest is, it looks like receipts and
The
invoices.
rest is, yep, receipts and invoices
Got
and
it.
all of that.
Okay, we are clear. Okay. Your defense.
Are you ready?
Yes.
First of all, we was not 2 months behind on rent on January, the middle of January, I did catch up all my rent.
January of 2022, you were
Correct.
caught up on your rent.
I gave him like almost $3,000 to catch it all up. The day after I gave him the $3,000 is the day the house got pink tagged. I do have a picture of when the house got pink tagged. It was done on January 18th, 2022.
2022.
Correct.
Okay, and do you know why the house was pink tagged?
I did not know at first until we received a letter from the city stating that the house was not registered as a rental house. It has not been done as the compliance code. I never heard about it once before. I have no reason to deny them. I had CPS in our house a couple times regarding our stepdaughter. So if I'm gonna let CPS in, I'm gonna let the city in to come do the house. So I have never once denied the fact of them coming in. I was never asked about them coming in, never was told that there was an appointment coming up. I did call and speak to Amy Castrol, which is the one who put the pink notice on the door. I do have emails between me and her discussing us working on moving out into, if she could please hold on red tagging the house before 2/17. I do have.
So the property was gonna be red tag 2/17?
Yes, correct. 2/17/22 is what it says. It says it must be in compliance or be vacated by then. When I asked Kevin about the pink tag, he told us that that was our 30-day notice and we needed to move out. When I spoke to Amy, she let me know that this is not a 30-day notice. He would have to take us to court to evict us. I did bring that up to his attention. Amy did hold off on pink tagging the house until we moved out, and I do have an email from me to Amy to let her know that we moved out February 27th. Out of the house. That was our last day there because Kevin kept calling us every day and texting us, talking about that that was not our house. We needed to leave. There was plenty of other houses. He told us before that he was not given any money to the city. I wish I had the text messages, but this is 4 years ago. I don't have that phone from 4 years ago.
I have them.
He has told us plenty of times that he does not give the city money because all they want is money, and he was not gonna do that. But I did pay up the rent and I was not there for March. Like I said, I do have an email from Amy, between me and Amy, letting her know that our last day was the 27th and she could go ahead and red tag that house whenever she was ready.
So you're admitting that you were there in February?
I was there in February, correct, but
Did you pay rent in February?
I don't think I did pay the February's rent, no. So that's the only one.
Okay, what about the damages that are being alleged to the property?
So We did leave a lot of stuff there, everywhere that we could not take with us. We did not have time to get a storage unit, let alone trying to find a place to live. We ended up going and staying with Joshua's father until we could find a place at such short notice. I was working on trying to get stuff cleaned up and like trash taken out, but as days kept going on and we were working on figuring out what we could take, what we couldn't, and where we could put it, he kept, like I said, he kept texting me, telling me that it's not his house or our house, that we needed to get out of there. He has another property right across the street from him that he would sit outside of that house and watch our house. And while he was texting us, telling us that we needed to leave and get out of there now. So we ended up getting overwhelmed by it, and we left what.
You got overwhelmed by what, ma'am?
By him constantly not even trying to work with us on moving out or getting out of there or getting the house inspected. Like he says the house wasn't registered because of COVID. I did get informed, and we did get some mail that the house wasn't registered since 2019. And that's when it expired. COVID didn't start until 2020. So I don't.
I'm on the website now. It's not true.
That's what we were informed.
Yeah, that's not the truth. The house was registered, it's been registered, and it did expire in 2020, and it's complied with after you moved out.
Well, he never said anything about the house not being registered to us, and I was told it was expired.
It doesn't have to be registered to you, it has to be registered.
No, to him, that's, yeah.
It has to be registered as a
Rental property.
Correct. Did you deny him access to the property?
No, I did not.
Okay. And so, you're saying that after you received notice that it was going to be pink tagged? So it wasn't pink tagged?
No, it was pink tagged.
Okay, so it was pink tagged in January. You said, and then you moved out the end of February. But I'm looking at the pictures and it's overwhelming. You talked about being overwhelmed by him making phone calls. It's overwhelming the amount of things inside the property. What did you actually take to move out? What did you take with you?
My kids' clothes and some of their toys.
Okay. And so you took clothes, toys, you left, literally there is bags of marijuana in the basement. You left bags of marijuana in the basement. Trash. Fecal matter. Trash. I mean, you only lived in this house for 2.5 years. The amount of trash that I'm looking at, no one should have accumulated in a decade. So how is it that anyone's supposed to believe that you moved out of the home with this much stuff in it?
I mean, I don't know.
And so in order for you to have turnover possession or say that you vacated the house, that means that he has to be able to have use of the home. He can't have use of it if all of your stuff is there.
I mean,
if just because you physically are not there, but you left all your things there, who was then responsible for getting the stuff out?
I mean, I should have been. I would have.
I get that, but when you don't, who then is responsible?
Like, he's left responsible, like made to do it.
Okay. And you are on the lease as well, sir?
Yes.
Okay, what did you want to add to this?
I don't think I have anything to it.
I surmise that might have been your response. I don't understand how, why did you have a cat? Did your lease say you're not supposed to have any pets?
He knew about the cat. He said that.
My question is, did your lease say?
Yes, the lease did say that.
Did you get it changed to the lease so that you could have a cat?
We did not get it changed through a lease. We never received another lease again after the very first lease.
It went month to month. That's why I gave them 30 days.
Okay, so it was supposed to expire June 2020, it looks like. And then it went month to month after that.
Yes. And I can show you also the day that they left. I can show you. I've got text message. I got the entire thread if you want to read it.
Oh, the text message, you can show her first.
Have at it. That entire pack of thing, you know, the first few pages talk about, you know, how my dad showed him the place, and then I signed the lease with him, and then.
Okay.
And then.
Well, I don't need you to tell me what's in the text messages. I want her to review and see if
Sure.
these are accurate reflection of the communications that you all had. And then I'll proceed with my questions.
All of it, and I can back it up with the phone too, so. He's my plumber guy.
Oh, okay.
He's the one who did the plumbing, and I didn't know if I needed him or not.
You might.
I was never informed about any cats either, by the way. I saw him in
Oh,
the.
sir,
I
you
saw-
can't, you have to wait until it's your turn to talk. Okay, ma'am, that seems like an accurate reflection of your communications.
Kinda, yes.
When you say kinda yes, what does that
The
mean?
beginning ones, definitely, I don't recall Kevin is the one who showed us the house.
And I'm not asking you if you recall anything, because I'm not asking you if those were text messages sent and received between the two of you all.
Most of them seem like it, yes. Some of them do not seem like it.
Okay, any other evidence or defense to the damages primarily to this property? Because what my concern is I don't, like, why is there tile missing off the kitchen? What's going on?
There was only one piece of tile missing off it that got loosened up when we were moving the fridges around.
You're moving the refrigerators around?
Yes, because we had our own refrigerators.
Okay,
So when we were taking our refrigerator
so
out,
you put your refrigerator, was that the stainless steel one? Is that a yes?
Yes.
Okay, and the tile went missing, what happened to it?
it like scraped off the ground. It was still in the house. It could have been like glued back on,
Okay,
but
why is there so much trash left in the kitchen?
because I didn't have time to clean it, because I was told I needed to get out of there and get out of there now.
Well, from the time the property was red tagged, you stayed there for another month.
Almost another month. Like, we were going there and trying to grab our stuff, and we like went and stayed with his dad's house. We weren't staying there every night. Because we were
Okay.
trying to figure out where we could move our stuff to.
When you vacated, did you let him know that you vacated?
I did not let him know that.
Okay. Did you turn over a key when you vacated?
I did not, because I did not have one of my own anymore. I lost one of mine.
So how was he supposed to know that you had vacated?
I did text him at one point in time and let him know that I had all my stuff that I was gathering, and I just had to get one of the cats out of there the next day.
When did you text that?
Last 3 pages.
The
End of
last-
February,
Last
1st of
3
March.
Okay, so I should be going all the way around.
It wasn't just one cat.
Okay, let's see here.
It should be date stamped also. March 15th, I think, was when I got clearance.
Okay, so you stated, sir,
Yes,
that you didn't know the house was not registered or that it was expired.
I
should
did
say.
not, I did not know that, no.
So where does it show me that they denied you entry to get the house inspected?
That was after talking to Amy Castillo.
What do you mean?
Well, I did know, on 2020, I did know, because I brought that to her attention. I remember that distinctly. We were standing over at my house.
You brought, how did you bring it to her attention? You said, I'm scheduling an inspection?
Yes, I'm gonna need to get an inspection scheduled because it has expired, so it needs to be renewed.
Okay.
And consequently, it needs to be inspected. And that's when I got the song and dance about, I've got an autistic child and I don't want anybody in this house and they're not coming in.
In the middle of COVID?
Yes.
Reasonable.
Sure.
What happened after that?
After that, I brought it up a couple of times, in person when I would collect money, rent, as it were, about the fact that it still needed to be inspected. and I kept getting blown up.
Blown off how?
Well, you know, I don't want somebody in my house. You know, and then after,
Who cares?
and after, well,
What's that got to do? What day did you schedule an inspection?
I did not schedule the inspection because it was gonna cost me $750 and I didn't have that money.
Well, that's
Because
not
they-
the same as they wouldn't let the inspector in.
Well, no, but I would have, you know, scheduled it had I had the money from the rent in order to do that.
Okay, so when they, so you're saying you didn't have the money because you weren't receiving rent?
Yes.
And so is that, you believe that's a reasonable defense to why you're not keeping up with your inspection sticker?
No. The reality of it is this, I wanted them to go, is the whole thing. And by this point, after I'd seen what I'd seen, I wasn't gonna have an inspection anymore. I wanted them gone and I was gonna sell the house. And that's pretty much what I did.
Okay, so then you let the inspection sticker lapse on purpose?
I did.
Okay, well, then you can't get rent after the inspection sticker lapse if you let it lapse on purpose. You understand that, correct?
Oh, okay.
Yeah, so I'm gonna call it a wash on your 2 months rent, but reality is, when I look at these pictures of how the property was, the condition it was left, it's completely disgusting. For you even to live here, never mind leave someone's property like this. I mean, there's trash, food, debris. I mean, it is completely atrocious that I am looking at photos where there is cat feces on carpets all over the place. And you were living there. And if it's true that you were so concerned about the health of your child, then you wouldn't leave your house like this. Because there's nothing about the condition of this house that promotes good health for yourself or for your children. I see piles of trash bags, piles of trash in the corner. There's not a wall here, and thank you for at least providing some context of what it looked like beforehand, but there's no area of this home that does not look like it was smeared with debris somewhere. And so it's not reasonable for you to leave someone's house like this. When you're vacating, listen, I grew up renting. And when we would move out of a home, we left the house in broom swept property. There were landlords that would call my mother back because how clean the house was when we left. You have no business leaving someone's property like this. And then I'm reading these communications and you have the audacity to act like you were in a position to own the home. Do you want to do a land contract? You're not even paying the rent on time. How are you going to be in a land contract? And now you want to act like you're a victim in here. How can you put a family through this? How can you do this to someone's home? How in the world did a perfume bottle get into the pipes?
I have the slightest clue on that. I don't know. I did not do anything to the plumbing whatsoever before we left.
Yeah, I don't know. I'm not saying that you did anything intentionally, but because it appears like it's just a reckless disregard. I don't believe that it was an intentional thing, but I don't know. He didn't call the plumber. I don't know if it's necessary because the plumbing, if I look at the damages that I think reasonably were caused to this or accrued to this home, the plumbing is one of the least of the concerns. You just had a reckless disregard for the home that you were living in, and it belonged to someone else. If you want to treat your space this way, that's your business when you own it. But when you are borrowing someone else's at a fee, then you should take better care of it. There shouldn't be holes in the wall. There shouldn't be fixtures ripped off walls and wires everywhere. The fact that you would do a grow operation in the basement is astounding to me in and of itself. But then to leave all the evidence of it there, reckless disregard. You could care less about the fact that you were doing whatever you wanted in someone else's home, and then you're going to leave because you said you were under pressure to leave, but then he has to clean it up. Even if he called you every day and asked you to move, he had never served you with an eviction. The pink tag tells you on there what your rights are. And you could have levied on those rights. You didn't do that either. Because in order for you to levy on those rights, you got to put your rent up in escrow to show good faith. And you didn't do that either. There's no good faith going on here in this house. You only got caught up because he was hounding you. So you gave him the little $3,000 because you had been in arrears. But then after that, you still held over his property. And then even after you leave, and I see here where he had to ask you, were you done? March 14th, are you done at 303? When can I get my keys? You had never told him that you had moved out, gotten all of your pets. March 1st, you're still talking about you got cats that's still there. You got to get your cat. Your cats were still living at the home. You did not vacate on February 27th. You're not being honest. I've seen enough of the pictures based on the fact that his rental certificate, he says now, was intentionally lapsed. I'm not going to be able to grant you rent for those months. Otherwise, I would. However, as it relates to your damage to the carpet, unreasonable. And I don't typically grant landlords for reasonable wear and tear. But this is only a 2.5-year lease period we're talking about. Yeah, there may be some debris or some dirt or whatever. You get the carpets professionally cleaned after 2.5 years if they were new or reasonable prior to. But this is disgusting. No one should do anything but trash that carpet afterward. And it's because of what you all did to it. The fact that there's brown substances leaking and seeping through a carpet to get down to the hardwood is just disgusting. It's completely gross. I'm granting him $2,819.45 for the repair and replacement of the carpet. As it relates to cleaning, he said he had to have someone come 19 days or 19 times at least to do the cleaning. 12,000 for 19. You've got a stellar cleaning person to charge that. Granted, judgment for 1,200 for the cleaning. Trash only $575 for what looks like. It looks like all the people who you allege live there must have all left their trash there. Although some of those people in the mail were her. Just looks like it was the name that she used in court today, which is Christina Fresh, and not the name that you put on your lawsuit, which was Christina Litmisky.
Little Misky.
I'm not sure how that got misconstrued, but it looks like even as she signed the lease, it's Christina Fresh. So nonetheless, I don't know how many people were living there, but there shouldn't be that much trash in a home. And if you're going to live there, then you take it out when you leave. You get you a dumpster and you clear it out. You don't leave that for someone else. You should be completely embarrassed. I wouldn't let anybody come and inspect it either if it looked like that, to be quite honest. I am going to grant for the trash pickup. I'm not granting for rent. The plumbing, I don't believe that the issue with the plumbing was caused intentionally. I think it was gross negligence. I don't know how in the world you could get a scrunchie and a perfume bottle down to cause this level of backup. And you clearly were aware that this issue was going on. And where did you notify your landlord of this issue? Never. Just a gross disregard for anything. And it doesn't even belong to you. At least have some care and concern enough to let the landlord know, we don't know what's going on with this. Can you get somebody over here? No, you're letting the issue compound and not address it or not properly address it. I'm granting him $1,044.04 for the plumbing. That's the total on that. $5,638.49 is the judgment of the court. Any additional matters for the record?
No, except for it was 14 grand.
I recognize that.
All I asked for was 7,000. That's half, I thought that was nice.
You thought you were nice when?
I thought, well, being nice with the half, plus the fact that, I would have had to hire an attorney to do the rest. And I don't have that money because I had to fix this.
Sir, I'm basing this off what you asked me.
No, I understand.
You told me carpet. You told me, plumbing,
Yep.
cleaning, and trash. You said you did not want anything for the rest of the flooring.
Oh, no,
I did not grant you anything for rent. So that's what brings you, otherwise I was gonna give you the full 7,000 you were gonna go over had I given you the.
well, it is there though. If you, the first page is well over $7,000.
You said there that you want the carpet. You didn't ask for all of the things that are on the page. I asked you specifically what you were seeking damages on. That's why I asked you.
Everything on the first page I'm asking, everything. It's all in the pictures. It's all evidence.
It's not what you said before. It's not everything on the pictures because you made it clear during your testimony. I don't want anything for the laminate. I just want the carpet.
No, that's not what I said.
That is what you said.
No, what I said was, I'm not asking for the bedrooms that the carpet was old in. The two back bedrooms. I want the laminate covered. Of course, I had to cover the kitchen floor. I had to cover the dining room. I had to repair it. And I had to pay a guy a lot of money in order to put it down also. So I mean, I'm.
You're saying
like
that
I say,
the carpet cost $28.19 did not include the labor?
Yes.
Okay.
Yes. And I didn't do the carpet, was what I was saying. I didn't do the carpet because I refinished the floor. I wasn't asking for the $4,800 that it cost me to refinish.
So you have not replaced the carpets?
I didn't replace them. I did laminate for part of the carpet, and I had the floors refinished for $4,800 for where the other carpet was. So I'm only asking for $4,414, which is the labor for the laminate and the carpet.
Got it.
Okay, so that's where I was at with that. It wasn't. I want that paid for. I had to buy it, and the receipts are there.
I see your receipts. My understanding of what you were requesting was for the carpet.
No.
But that you did not want the flooring.
No.
So you are requesting for
what I've got
the flooring. You have. Let me ask my question, sir,
Okay.
because that's how we go. There's a miscommunication and we need to get on the same page. What you're saying is there was instead of replacing the carpet, you got the floors refinished.
Yes.
Because the carpets were destroyed.
Yes.
And it cost you how much?
It cost me $4,800 to have the floors refinished.
And you have, let me ask the questions, you give the answers now. But a portion of it, you had to put laminate because it was so destroyed.
Yes.
That you could not even refinish it.
Yes.
And then the labor for, what is the labor 1188 for then?
That's the laminate labor.
Laminate labor alone was 1188.
Yes, that's that, and actually that was a reasonable price because he only charged me $3 a square foot, and the people that put down laminate generally get a lot more than that, like $5 or $6 a square foot, I believe.
Okay, so for flooring, your damages are $4,014.
Yes.
Again, plumbing $1,044.04. Plus cleaning of $1,200.
Yeah.
Trash is $575, which will take you over. So your max is 7,000.
Yes.
That's the judgment of the court.
Thank you.
I'm going to give you, I might have mixed up your paperwork. Now, let me figure it out. This has the text messages and the other exhibits. That's your your pictures back. And then I'm going to sign the order.
Oh man, oh man. Oh, look at that. Look at the little puppy there. Well, pro se guy got his judgments from the nasty tenants. Oh man. I cannot believe that Old Squishy is the one who actually found that one, but I figured we would have to discuss this in chat tonight. So that was my presentation of the nasty case in front of Judge Simpson. Simmons this evening. We'll see some Simpson tomorrow. I promise. Well, maybe, possibly. We'll be back in about 11 hours, ladies and gentlemen. We have the weekend review starting at Saturday at noon, 11 a.m. Central Time. And the puppies will be with us. So, ladies and gentlemen, come on by and hang out. I'm your Lone Wolf Usul. I am your curator for these here videos. I am your host for this here get-together every single night of the week. Same wolf time, same wolf channel. And I do want to say a very special thank you to Hannah, Gen X, Original Daniels. Oh gosh, I can't see the rest of your name. Original Daniels something. I know there's more to your name. Thank you so very much. And Hutch, guys, y'all are great. Until tomorrow, ladies and gentlemen, when we will have lots more court to watch. Thank you so much for hanging out. I'm your Lone Wolf Usul, and I am out. Leroy Jenkins. See you in the morning. Night, y'all.